we do have a bench trial at 11 o'clock.
All right.
So I told him to send somebody in here if it goes over so I can go to lunch. But she was like, well, I said, well, I'll stay, but you gotta give me my lunch. She said, well, no. But she said, well, you'd have to leave early. I said, well, you gotta send somebody in here.
Figure it out. Right?
Yeah, they'll figure it out.
They will let you- This is case number 21-167-180. This is Discover Bank versus Cynthia Warren. The matter is before the court, set on for a pretrial conference. Counsel for Discover, your appearance at this time, please.
Good morning, Your Honor. Jennifer Dillow, P69855, appearing on behalf of the plaintiff.
All right, thank you, Ms. Dillow, and good morning to you. Do I have Cynthia Warren on the Zoom? If you're on the Zoom, please say something at this time.
Yes, good morning.
All right, good morning, Ms. Warren. It looks like to me that a judgment was entered in this matter on April the 25th, 2022. And then I received a notification that the defendant was in hospital. And I sent the matter over for review subsequent to that time. I have received the answer was filed in this matter back in February. Madam Counsel, update me on where we are with this matter. I do see that
I'm sorry, Judge, can I interject for 1 second, please?
No, not at this time. I do see that I did set a scheduling order in this matter, and that today is the last day for discovery of this matter, and I sent the matter on for review accordingly. Madam Counsel, update me at this time. I'll come to this morning in just a moment.
Yes, Your Honor. When we were here last for the last pretrial, we did address the default judgment. It was determined that the court entered that in error because the answer had been filed. We hadn't received a copy of the answer, so we sent in our default judgment. And I believe that the court set the default judgment aside at the last hearing on May 26th of 2022. Although I don't see an order, but I believe the court set that aside. We have since also filed a motion for summary disposition to be heard today in accordance with the scheduling order.
All right. I believe that is an accurate update as to the status of things. The problem that I did run into is that I do not see an order reinstating the matter, although I know that it's been reinstated. That is that the judgment has been set aside. So I will make sure that the file is updated with an order indicating that judgment was set aside. I have received, of course, the answer as I previously indicated. I also would note that I have not received your motion for summary disposition. It hasn't populated to the court's file. All right, so Ms. Warren, did you have something you wanted to tell me, ma'am, at this time?
Yes, a couple of things. I know on the last hearing, you stated that just like the attorney said, that the judgment was set aside because.
Let me stop you for a moment. You don't have to repeat anything that I've already covered. Okay. So the judgment, the default judgment is set aside. I set a scheduling order, and then I set the day for a pretrial and also for motion hearings today. Now I've updated everything. Now, if you have something else that you wanted to add, go ahead, ma'am.
Yes, I had wanted to let the court know that I am on a fixed income. I'm an elderly woman, and I have retained an attorney to file for bankruptcy.
All right, so let's deal with the latter part first. Has a bankruptcy petition been filed yet, ma'am?
No, I've just spoken with my attorney.
How long ago?
Within the last couple of days.
Okay, so are you going to file a petition in bankruptcy?
Yes.
Okay. All right, so once that is filed, then the bankruptcy petition will operate as a stay of this case. It will stop the case from moving forward. But until there's something filed in bankruptcy, then I don't have anything that stays the matter up until that time. Did you receive a copy of the motion that council filed, a motion for summary disposition? Did you receive a copy of that?
No, I have not.
Council, when did you file your motion?
Your Honor, it was filed, it looks like June 13th, 2022 on the Register of Actions. We served the defendant on June 7th of 2022. Our mail has not returned.
Let me have a register of action. Just one moment. Let me see what's been generated in our computer. I know that the motion is not populated to the file. That doesn't mean that it wasn't filed. It doesn't mean that it wasn't put on the register. Let me just check now and see where we are. All right, and I do see that a motion for summary disposition was filed with the court on the 13th of June of 2022. That's the date that we have for filing. And it indicates that it was sent to the judge. And that's the only part that I don't have. It's not in the court's file. But yeah, the court would acknowledge that it has been filed with the court. And all right, so I haven't had a chance to take a look at the motion. The defendant indicates that she is likely to file a petition in bankruptcy. So what I'm going to do is I'm going to put this over for 2 weeks and come back for a hearing on the motion. So let me give you the just before. What's my last day?
You did it on 17th, August 17th.
So it's on for that.
We leave the 22nd. So you want the last, leave this week. So the 22nd, the 17th.
Oh, the 17th.
Yes. If you want something before that, you have a trial on the 10th.
All right. The 17th, August 17th, 2022. I'm going to set this at 10 o'clock a.m. And I'll make sure that I get that motion. I don't know where it is, but it's here because it's been acknowledged as filed. Madam Counsel, if you would be so courteous as to send mail another copy to Miss Warren, because I will be hearing the motion and making a decision on that motion at the next hearing. And Ms. Warren, if your attorney files a petition in bankruptcy, they will know what to do. They will send the appropriate paperwork to the opposing counsel as well as to the court. You understand, ma'am?
Yes.
All right. So August 17th, 2022 at 10 o'clock a.m. I will hear this matter, hear the motion on that date. Is set for the motion hearing at that time.
Thank you, Your Honor.
Just one moment.
Can the judge get the email? Yes, we don't have it down.
And Madam Counsel, if you would email a copy of that motion as well, just so that, because we're having some problems locating it. So the email address where you would want to, oh, you know what? Wait a minute, I do have it. I do have it. Well, and it's pretty thick, so don't email it.
Okay.
I do have it. I just found it. And as a matter of fact, I read the motion. I read the motion when I received it. That's why it's here on my desk and off to the side. I'm sorry. So I have received the motion. Given that the defendant said that she did not, I will go ahead and send it over for that date that I've set it on. And then I will hear the motion at that time. And again, if there is a petition in bankruptcy filed in the interim, then I will address that at that time as well. All right, good day to both sides. See you on the next action.
Thank you.
Thank you.
All right, the court now calls case number 21-167-687. This is HS Financial Group versus Jania Waller Bay. The matter is before the court on the application for a subpoena. This emerges as a result of the entry of a judgment on the 8th of March of 2022. That judgment is for $2,197.90. Do I have counsel for HS Financial on the Zoom?
Yes, right. Daniel Weberman, P76609 for plaintiff.
Thank you, Mr. Weberman. Good morning to you. Do I have Jania Waller Bay, I believe it is. If you're on the Zoom, please say something at this time. I'm looking for a person whose address is on Orleans Street in the city of Detroit. Last name Waller Bay. If you're on the Zoom, please say something at this time. All right, the matter is set on for 9:30. It's now 10:12. It appears the defendant has not appeared on the subpoena. Counsel, you did get proof that the subpoena was served. Is that correct, sir?
Correct. Service on June 2nd, 2022.
All right, thank you, counsel. Your pleasure at this time, sir.
I will request a show cause.
The court will grant the petition for a show cause and will set the matter over for
Wait, when you come back in September 8th, September 14th.
9/8/22 at
Yeah, true, sir.
9:30 a.m.
All right, thank you. I'll have it sent in.
All right, thank you, counsel. Now, upon receipt, the court will sign off on it and get it all set up. 9/8/22 at 9:30 a.m. Thank you, sir.
Thank you.
The court now calls case number 21-168246. This is HS Financial versus Chanel Mosley. The matter is before the court on an application for subpoena in order to appear. Today is the time set for a hearing regarding this matter. Counsel, your appearance, please, sir.
Daniel Weberman, P76609 on behalf of the plaintiff.
Thank you, Mr. Weberman. Do I have Chanel Mosley on this Zoom? Say something if you're here, ma'am. Chanel Mosley. Looking for a person living on Collingham Street in the city of Detroit, Chanel Mosley. It appears the defendant has not appeared regarding this matter. The respondent and counsel, it appears that service was made on the subpoena. Is that correct, sir?
That is correct.
All right, and you are asking now that the court grant your petition for show cause. Is that correct, sir?
That is correct.
The court will grant the petition, set the matter for 9/8/22 at 9:30 a.m. And I'll sign the proper order upon its presentment, counsel.
All right, thank you very much, Your Honor. Have a good day.
All right, thank you, counsel. The court now calls case number 22-178-401. This is Evidence and Mutual Physical Therapy versus Michigan Millers Mutual Insurance Company. The matter is before the court. It looks like on a motion for summary disposition. Your appearance at this time for the plaintiff, please.
Yes, good morning, Your Honor. Connor Clardy, P84485, appearing on behalf of the plaintiff.
Thank you, Mr. Florida, and good morning to you. For defendant, Michigan Millers Mutual Insurance Company, please.
Good morning, Your Honor. Ken Lupo, P65439, Michigan Millers.
All right. Thank you, Mr. Lupo, and good morning to you as well, sir. All right, so somebody update me on where things are regarding this matter.
Your Honor, we were scheduled for a pretrial today. Just in the interim, it was raised at the last pretrial that there was a utilization review. I forwarded that information to plaintiff's counsel and then filed the motion that's set for hearing today.
All right, yeah, and I remember now the utilization process that was on the way. And Mr. Florida, anything you wanted to bring to the court's attention regarding the status of things at this time?
No, Your Honor, not regarding the status of things. I have a lot to say about Mr. Lupo's motion, but nothing about the status of the case.
Gotcha,
Everything
sir.
he said is accurate.
All right. All right, thank you. And counsel, you may proceed with regard to your motion for summary disposition in this matter, sir.
Thank you, Judge. So after this accident on March 19th of 2021, the claimant received physical therapy from plaintiff. It was from April 23rd, 21 to October 5, 21. So during the course of this treatment, a utilization review was completed pursuant to MCL 500.3157A sub 4, and it was determined that therapy had been overutilized. And defendant issued a denial letter based upon that utilization review, denying treatment after May 22nd, 2021. Treatment up to that point in time was paid for, and in fact, defendant had already issued 5 additional payments after May 22nd, 2021 for additional days of service. It's about $2,000, which they're not seeking in this case. Plaintiff did not appeal the utilization review, which it was required to do within 90 days under the rules promulgated by the Department of Insurance and Financial Services. And they were directed to do that under 500.3157A sub 3. And not only do these administrative rules that DIFs made govern appeals, they established the criteria and standards for the entire utilization review process. This is clearly an administrative procedure. And the administrative rule 500.65 sub 7 states that a decision on appeal is only subject to judicial review as provided for by MCL 200.44 sub 1. And that statute in turn states that a person aggrieved by a final order or decision may seek judicial review in the manner provided for under the Administrative Procedures Act, which is MCL 24.301 to 24.306. And now under that Administrative Procedures Act in turn, it states only when a person has exhausted all administrative remedies within an agency and is aggrieved by a final decision, can a decision be subject to direct review by the court. Now, because plaintiff did not exhaust all its administrative remedies, there's no final decision for them to seek judicial review from this court for, and summary disposition for lack of jurisdiction is appropriate when a plaintiff has failed to exhaust its administrative remedies. In plaintiff's response brief, they argue, well, we didn't have to appeal because 500.3157A sub 5 states that a provider may appeal the determination to the department. I don't disagree with that. Nobody ever has to appeal. But this utilization review is an administrative procedure, and the rules are clear that you cannot file a lawsuit in the circuit court or a district court or any court if you have not exhausted your administrative remedies. When you don't appeal, you are accepting the results. And it states as much in 500.3157A sub 1. I think it's clear here, Judge, and I would request that the court grant the motion.
All right, counsel, Ms. Clarity, with regard to the exercise of the administrative process of review, is it in fact true that that evidence in neutral did not engage in the administrative appeal or review or seek to have the administrative decision that was made regarding utilization review?
Your Honor, just let me answer your question first.
Yeah, I figured you weren't gonna answer that one on the nose. And essentially, the second question is connected to the first one, and as you answer in the fashion that you choose to do, the question here becomes whether or not we can drill down on whether or not the administrative process of remedies were exhausted, because that's the crux of the argument that's being made here. And what comes after that, obviously, is what the implication of that is. But counsel argues factually that the administrative remedies were not exhausted because there was no appeal from the determination of the review board. You may proceed at this time to support it in the fashion that you choose.
Yes, Your Honor, thank you. I do want to answer your question. This appears to be somewhat of a case of first impression in terms of utilization review. This process came about through the 2019 amendments to the No Fault Act. And so I'm going to answer your question first, Your Honor. No, an appeal was not taken by plaintiff to the Department of Insurance and Financial Services. That did not occur. My argument, though, is that they had no obligation and there was no requirement that they had to file an appeal through the Department of Insurance and Financial Services DIFs. If you read the statute, Your Honor, in particular, look at MCL 500-317A sub 1. And if you look at the end, it says that a physician, hospital, clinic, or other person who renders medical treatment is considered to have agreed to both of the following: to submit necessary records and other information concerning treatment, products, services, accommodations provided for utilization review under this section, and B, to comply with any decision of the department under this section. But in order to actually get in front of the department, you have to file the appeal. And we have to be careful, because I think we can all agree that the legislature says what it means and means what it says. We can't read extra language into the No Fault Act. We have to go with what the legislature is saying. So we have to, look at the words that are used. May is not a command from the legislature. It's not something that suggests that, okay, in order for you to proceed with your
Ms. Brooks, you're unmuted. I'm coming to you shortly, ma'am. So I'll mute
Oh,
yourself.
I apologize. I'm so sorry.
The legislature, if they wanted to pin a provider to this process, would have said you shall appeal, that you must go through this process. Nowhere in the No Fault Act does it say that. It doesn't say that, and to rule otherwise or to determine that that's the case would affect every provider's due process rights in the state. They have independent causes of action. This statute is optional. It does not mean that they have to go through an appeal with DIFs. It just says that they have to go through utilization review. If you look at subparagraph 6, it defines utilization review for us. It says utilization review means the initial evaluation by an insurer or the association created under section 3104 of the appropriateness in terms of both the level and quality of treatment. They agree by providing services to agree to utilization review, that they will provide their medical bills to an insurer so that they can complete a utilization review. It doesn't say that they have to do an appeal through DIFs. That's not their sole remedy. They can choose to file suit in district or circuit court, just as they've had for the, since the beginning of the No Fault Act. This is not something that's mandatory to rule. And if you think about the conclusion of it, it would kind of lead to this absurd result. It would mean that the insurance company would get to decide unilaterally that they believe that a bill is too high. And that's an absurd conclusion.
So this process is put in place, and you said that your argument is that it's voluntary and that any decision made under the Michigan Department of Insurance and Financial Services rules does not have any teeth to it. It doesn't have any bite to it. You can opt into it, out of it, it doesn't have any consequences. Is that what you're arguing?
I'm arguing, I'm sorry, I know I'm all over the place with it, but no, what I'm saying is that the decision under utilization review is really not made by diffs. It's made by the insurer or a contractor that's hired by the insurer. In this case, it's Corval. If you look at defendant's motion for summary disposition in the exhibits, it doesn't say anything about diffs. The insurance company through Corval is conducting the utilization review. No decision or determination by diffs has been made. Right? The determination and decision of diffs would happen if you filed an appeal. And they don't have to do that. It says it very clearly in paragraph 5 that they may do that.
And why would they not file an appeal of such a determination?
Because it's as soon as they file an appeal, Your Honor, if a provider files an appeal through diffs, they bind themselves to diffs decision. Then they have to go through the Administrative Procedures Act. If a provider says, okay, I'm going to appeal and see what diff says, what they just decide, then they're binding themselves to that process. That's my argument. But in this case, my client did not do that.
All right, Mr. Clerk. Counsel?
Yes, Judge. Plaintiff already bound themselves to the whole procedure by being a provider that's rendering treatment and seeking compensation under the Michigan No Fault Act. This entire process is under administrative rules, not just the appeal, but the submission of proofs, what each party has to do. This is an administrative act. You don't have a choice whether to be involved with it or not. And it is not the insurance company that's unilaterally deciding anything. It goes to the review, and then the plaintiff or the provider appeals. So there's no unilateral determination, and there's nobody's required to appeal anything. Perhaps the provider will agree with the determination. So why would the statute say shall and force them to appeal something they don't agree with, or that they do agree with? I'm sorry. So there's never any requirement to appeal anything. But if you're disputing what was determined, then you have to appeal. It's administrative procedure. You have to follow the rules. And these several rules, they seem to cite each other quite a bit. But the ultimate finding here is that if you don't appeal and you don't have a final order or a final determination from the administrative process you're supposed to go through, then there's no lawsuit to file in a court because there's no subject matter jurisdiction. You have to exhaust your administrative options here, and that was not done in this case.
Is there anything about the diffs rule that sets forth anywhere in the body of those rules that this process is a voluntary administrative process?
Your Honor, as far as I know, no, but I'm not sure if I'm presenting what I'm saying clearly. I'm saying that if you go through an appeal, according to the state legislature, right, then you bind yourselves to decision. That's what I'm saying. But in this case, that did not happen. And the state legislature is saying that you don't have to go through that process. They're saying you have to go through utilization review by providing the service. And I want to respond to Mr. Lupo's point to that. They have to provide medical records to support the treatment that they gave to the insurance company so that they can do a utilization review. They have to go through utilization review, but that is not the appeal. The statute is simply saying if you render treatment, you have to provide medical records to the insurer so that they can decide whether or not there was an overutilization.
Right. I don't think that either party disagrees on certainly on that part of it, that there is a requirement to participate in the overutilization review. The question is, when there's a determination made, what is the impact of that determination? There seems to be while there is in the statute a provision in the administrative rules, I should indicate a provision that says that that a party may appeal the determination. The sense of that would seem to be that there is some impact from the decision made by the administrative review that wherein a person would then have due process rights that would give them an opportunity to change, overrule, or have the determination adjusted by exhausting administrative remedies. Mr. Clarity argues, Mr. Loophole, that it's only when the insured seeks to, when the insured seeks to have a determination changed or appeals that determination, that they then are in the obligation to the determination that's been made. Mr. Loophole.
Yeah, just a couple more points, Judge. It's, I think you've encapsulated the arguments there pretty well. This statute has to mean more than something that says that a provider has to provide documents. They already had to provide documents before these amendments were even made under 500.3142. You had to provide reasonable proof of the fact and amount of loss sustained. So this can't just be, you have to provide documents. They already had to do that. To say that this whole thing is voluntary and you don't have to appeal and the utilization review doesn't mean nothing. I mean, it basically renders this whole statute meaningless. If there's no teeth, there's no requirement, there's no obligation to do anything really. And that's not what the entire purpose of this statute was for. It's an administrative procedure. It's set up where you're subject to the decision, and then you appeal if you don't like it. And if you don't appeal, then that's it. You can't go to court. You can't file a lawsuit. Otherwise, there's just really no point to it.
All right. All right. I've heard the arguments on the defendant's motion for summary disposition in this matter. And I think that the record is quite clear as to the divergent positions that are taken by the parties herein. It seems to me that the statute that gives rise to the administrative review and that provides or makes provisions for there to be the right to appeal through an administrative process, by definition, gives bite and teeth to the administrative determination. That is that administrative determination then becomes a predicate, or addressing that becomes a predicate to whether or not you can advance your cause. And addressing that administrative determination requires the exhaustion of administrative remedies made available by the statute and various rules that have been generated as a result of the legislative scheme of this matter. Accordingly, where the plaintiff in this matter did not take an appeal or advance through the administrative process, they failed to exhaust administrative remedies in this regard. And accordingly, they have not met the predicate for advancing this matter within the judicial process at this time. I know that that there are not many of these cases that have come through this court as these rules have began to be enforced and implemented secondary to the amendments made by the legislature. But as it relates to the claim that is brought before this court, where there has not been an appeal of the determination regarding overutilization, then that predicate would be a necessary predicate to the plaintiff bringing this action. Plaintiff having not taken that step, he cannot proceed with the action at this time. That's my determination. Accordingly, the motion for summary disposition will be granted under the analysis set forth by the court and based upon the record as set forth herein. So ordered.
Thank you, Judge.
And, Mr. Lupo, you present an order in this regard. Mr. Clarity.
What's that, Your Honor?
Well, I thought you said something, sir. I was listening to you.
Oh, I was just thanking the court.
All right, thank you. Good day to both of you. And Mr. Lupo, you can send that order to Latifah, Latifih, Lita I'm getting it wrong, LATIFAH dot Hunter at 36districtcourt.org, 368, 36districtcourt.org.
I will do that. Thank you, Judge.
Thank you. Good day.
Thank you.
Judge, I'm sorry to interrupt. I just wanted to let
Go
the
ahead.
court know that we were settled on our case before I logged off.
All right, let me go to the one that you have. What's the suffix on your case, Ms. Ambrose?
It is, well, it's prompt rides versus City of Detroit, and it's 21-169423.
I don't,
Should be there.
it should be there.
Mhm.
This one,
Under 275.
the last four is, last
The last four is 9423.
9423.
Mhm. Like towards the bottom.
All right, and this is case number 21-169-423. This is Prompt Ride Incorporated versus City of Detroit. The matter is set for a pretrial hearing on today's date. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Christina Abro here on behalf of Prompt Rides, P78224.
All right, thank you, counsel. For defendant.
I believe defendant has logged off, Your Honor. We did resolve this matter. I did tell her that I would let the court know.
All right, so is this a matter that requires city council approval, or what's the next step in this matter? Somebody's going to submit an order, what's going on?
I believe defense is going to submit the order, Judge. I don't think it requires city council approval because it is under the whatever their limit is of, I think, 2,500 or something like that. So it's a pretty low amount. We've agreed to $1,750, and we should be able to get it wrapped up as soon as they send me closing documents.
All right, very well. So I will note on the file that the matter is pending dismissal as a result of a settlement reached by the parties. So,
Correct, Judge.
thank you, counsel. Good day.
Thank you. You as well.
And Your Honor, we have another matter that also is resolved.
All right, just one moment.
Thank you.
All right, and which
And Your Honor, we're just going to do a scheduling order on ours.
okay.
I think someone's unmuted. The case I was referring to, the last four digits are 1035.
All right, this is case number 22-181035. This is Philemon Marbury versus Liberty Mutual Insurance Company. Today is a time set for a hearing regarding this matter. For the plaintiff, please. For defendant.
Oh, I'm sorry. Joy Weber for defendant, P77088.
David O'Keefe for the plaintiff, 74989.
All right, gotcha. Thank you to both of you, and good morning to you. So you've got this resolved, Ms. Weber. Go ahead and talk to me.
Correct. I'm just asking for 21 days so we can submit final closing paperwork.
That makes sense to you, counsel?
It does. Thank you, Your Honor. Thank you, Joy.
Thank you.
The court will indicate that the matter is resolved, and the parties will submit an order closing the matter out within the next 14 days.
Understood. Thank you.
Thank you.
Appreciate it. Good day to you.
You as well. Thank you.
And then, Your Honor, we're just going to do either adjourn or do a scheduling order on our case.
All right, and is this the first time that it's up with me?
Attorney Parker, is that the
Yes,
correct?
we have a good cooperation between the parties. We'll get the case worked out. Citibank and I settle just about all our cases, and we can resolve it pretty quickly. If you could just give us a 60 to 90 days discovery order, Your Honor, we'll return the favor by getting this off your docket.
Yeah, that's fine. I agree.
One second here. Case number 22-177, it's right there, 178-778. This is Citibank versus Alice Knox. The matter is before the court set on for a scheduling conference. That's what I have it set for today. Your appearance for the plaintiff regarding this matter.
Good morning. J. Latif Beg, BAIG, P36820, appearing on behalf of plaintiff and the attorney of record.
Thank you, counsel. For defendant at this time.
Yes, thank you very much. Good morning to you. This is Brian Parker, 48617 for the defendant.
All right, thank you, Mr. Parker, and good day to you as well, sir. All right, gentlemen, off the record, you did indicate that you were moving forward in terms of advancing this cause before the court, and that you would appreciate a scheduling order from the court to allow you to continue in that process towards moving this in some type of reasonable position to maybe even get it resolved. Is that correct?
That is correct.
Yes, thank you. Good memory, Your Honor.
All right, so I'm going to go ahead and set it over. I'm going to set it up on a roughly 60-day scheduling order. As long as parties are moving forward, then those things work pretty liberally in front of me. What I don't like is when folks are just sitting on time and not doing anything. So I'm going to set it up for 60 days. If at some point, of course, you needed something a little more than that, then you'll be able to tell me about that. So I'm going to give you a new date to come back. That date's going to be
September 28th.
9/28/22, and that's going to be at 9:45 a.m. 9/28/22. Discovery will be open through that date. You may engage in discovery through that time, and you will have a hearing on that date. Also, you may file motions, dispositive or otherwise, and set them for hearing on that date. That is the 28th of September of 2022. So long as you allow the other party at least 10 days prior to the hearing date to respond to any motion that you might file. So if in the interim of your advancing this matter, you believe that you found something that is dispositive or otherwise that you'd like to make sure you get a hearing in the near term with the court, then set it for hearing on the 28th of September. And just make sure that you give the other side at least 10 days to respond, and I will hear it on the pretrial date, which is the 28th of September. So you'll get an order from me with that information contained in the order. I just kind of went over it, and other items like setting it up for trial, we'll address that at another point. But discovery and the filing of motions, notwithstanding the court rules, the court has shortened the time for filing motions and for having them heard if you wish to do so within the time frame or within the framework of the scheduling order that you'll be receiving from me in the mail in the next few days. All right. You got it, Mr. Parker?
Yes, Your Honor. Thank you. I see you working hard during these troubling times. Thank you.
Thank you, Judge.
Thank you. You got it as well, Mr. Page? Yes, sir. All right.
Thank you.
All right, sir. All right. I'll get that out to you right away. Good day.
Have a good day, everybody. Bye-bye.
Case number 21-165-707. This is Jacqueline Spearman versus Across the Park Apartments. The matter is before the court set on for a non-jury trial on today's date. Who do I have on this? Do I have Jacqueline Spearman? Okay. Yeah, that's good. Yeah. All right, this is case number 21-161-839. This is Coleman, L. Potts versus Riverfront Tower Apartments, AMP Residential and National Credit Systems Incorporated. Your appearance for plaintiff in this matter.
Good morning, Your Honor. Ryan Hill, P68445 on behalf of Mr. Potts.
Thank you, Mr. Hill. Good morning to you, sir. For Riverfront Towers and other defendants, your appearance at this time, please.
Yes, Your Honor. My name is I. Matthew Miller, P51351, here on behalf of the defendant's counter plaintiff.
All right, thank you, Mr. Miller. Good morning to you again, sir. All right, so I know that there was the filing of a counterclaim. The court extended this matter. Update me, someone tell me where we are with this regard to this matter.
Judge, we actually held a deposition yesterday. We've sent some discovery requests. We need to file a motion to compel, so I'm going to need a motion to compel date. I'm hoping after the court rules on our motion to compel and we get the information we need. I think after the deposition yesterday, I think Mr. Potts is going to be filing a motion for summary disposition as it relates to our claim as well as their counterclaim. But we are going to need some additional discovery that counsels refused to produce.
Mr. Refused to produce some discovery?
Well, not refused, just basically objected, saying it's overly broad, although it's not. So that's why we need a motion to compel date, Judge.
Your Honor, I answered the discovery on May 24th. We were before Your Honor on we entered an order before Your Honor on May 26th. Plaintiff has not lifted a finger in the intervening 2 months until they scheduled one deposition on literally the last day of discovery. So the only reason that there's a delay is because the plaintiffs haven't done anything. So I would oppose the extension, Your Honor.
So it sounds like to me that the only thing that that remains before this case can move to the next stage, if you will, is to resolve the discovery issue with respect to what was it? Some interrogatories or requests to admit. Which one? Or both, Mr. Hill?
Interrogatories, Judge.
All right. And have the two of you at all talked about what specifically Mr. Hill is looking for?
No, this is the first time hearing of this.
Well, no, it's not. And Mr. Potts brought this to your attention shortly after receiving the responses, Mr. Miller, but that doesn't surprise me that's your response.
All right, we'll do this. I'm gonna send the two of you into a breakout room. And I know there's a little bit of vitriol, but I'm not real concerned about that part. And just to specifically lay out the items that you are requesting discovery on or additional information, and I will address that. I will address those items today.
Thank you, Judge.
So here you go. I'm going to give you the opportunity to go into a breakout room and go over those items and come back in. I'll address. We'll drill.
Thank you, Judge.
All right, this is case number 21-167075. This is ASP Cares Pharmacy versus Citizens Insurance Company of the Midwest. For the plaintiff, your appearance at this time, please.
Good morning, Your Honor. Doug Harris-Gavich, P81458 on behalf of the plaintiff.
All right, good morning to you, sir, Madam Counsel.
Good morning, Your Honor. Amber Gearbaugh, P73448 for defendant citizens.
All right, welcome back. I remember this case just a little bit, but somebody go ahead and update me on where things are at this point.
Yes, Your Honor. We actually just settled moments ago.
We did.
Oh, well, my frustration with some of the cases this morning going on and on has proved to be beneficial ultimately. in at least one case. You don't have to answer that. You got it. All right, so somebody's gonna submit an order in that regard, or do you need any further involvement from the court at this time?
Nope, I think we should be able to have the closing documents to the court within 21 days.
So I'm gonna set it up, I love 14 more than I love 20, so more than I love 21. So if you get those documents to me in the next 14 days, that would be awesome.
Will do.
You certainly can email, and I'm gonna give you the email address. That's Latifah, Latifah, .hunter at 36districtcourt.org.
And that's 36, the actual numbers.
Yeah, 36th.org. And her
Okay.
name again is Latifah, Latifah .hunter. All right, good day. Good seeing the two of you. I'm glad you got it worked out.
Thank you.
You as well. Thank you, Your
Have a
Honor.
good day, Your Honor. Thanks, Deb.
Thank you.
All right, the court calls case number 22-180066. This is Calvary SPB 1 LLC versus Edmund Cowan. The matter is before the court, set on for a status conference, a scheduling conference. Your appearance at this time for the plaintiff, please.
Good morning, Judge Coleman, Sazan Barda, P65425.
Thank you, Mr. Barter. Good morning to you as well, sir. I'm looking now for Mr. Edmund Cowan. If you're on the Zoom, say something at this time, sir.
Oh, yes, this is Edmund Cowan, present.
Thank you, Mr. Cowan, and good morning to you as well, sir. I do see that there was an answer filed to the complaint in this matter. The complaint that was filed alleges damages in the total amount of $2,129.05. And the defendant in his answer indicates simply that he doesn't owe the plaintiff the money that is alleged in the complaint. So, Mr. Cowan, let me just begin with you in regard to this matter. So, do you have any indebtedness with Citibank or any connection to Calvary, sir?
I do have connection with Citibank. I did have a contract with Citibank.
Well, you know that this debt is being sued on as an assignee of Citibank. Someone owns the debt that you have with Citibank, and they're suing in that regard. You understand?
Are they? Well, I want to know: are they suing in behalf of Citibank, or are they suing on behalf of Calvary? I mean, that's my whole.
Yeah, it appears
Because when they first initially contacted me, they said that they are collecting a debt behalf of Citibank. And when I called Citibank, I attempted to make some arrangements with them, and they couldn't find anything. Like the lady guest told me it was set off or charged off.
Yeah, what they've likely done is they've likely sold the debt to Calvary, and then at law, Calvary is seeking to collect on the debt. That's what these cases typically involve. Let me hear from Mr. Barber, sir.
Your Honor, that is correct.
Yeah.
Actually, Your Honor, if I may, so Mr. Cowan did contact our office in 2017 and entered into payment arrangements and made payments for 2 years, and then stopped making payments, and that's when we decided to seek collection through the courts. Mr. Cowan did make a lump sum settlement with me which was below my authority, but I am going to submit that to the client, and hopefully that lump sum settlement will be approved and we won't have to come back. So I think in the meantime, we're just looking for dates to try to get this resolved.
All right, so, okay, thank you for the update. Is that about the size of Mr. Collins? Has the payment already been made, a lump sum, or has there been an offer of lump sum off?
He's made an offer of lump sum within 60 days, and I just need to get approval from the client.
That makes sense to you, Mr. Collins,
Yes, I pretty much want to get it done and over with. I was misled into entering a contract with Calorie, so I'm trying to figure out the just try to make an offer, get it over with. If they accept, then of course, if they do not accept, then we're gonna be back in court. But they misled me thinking that they are representing Citibank. They present themselves. They did not present themselves as a third party collector. That's my whole. If they represent themselves as that, then I would have not entered a contract or any type of payment arrangement. So I guess I'm kind of in between. So if they accept, I just want to get it done and over with.
Got it. Thank you, Mr. Collins. All right, so counsel, if I simply set this over for 30 days, would that at least give us some information as to how, as to whether or not this can be resolved on the terms as put on the table, sir?
Yes, Your Honor.
So that's what I'm going to do. I'll go ahead and adjourn it before taking further action in the file for a period of 30 days. We'll give you a new and specific date to come back to get this matter resolved, to see if it has been resolved. And that date's going to be
September 1st.
I'm sorry.
September 1st.
September 1st, 9/1/22, September 1st. And that's going to be at 9:30 a.m. A new notice will be generated, but you want to note that date, September 1st at 9:30 a.m. And I'll review this matter at that time. Hopefully it's resolved. If not, we'll figure out what to do from that. All right, good day to the two of you.
Thank you, Your Honor.
Thank you.
And we're back on the record regarding the suffix 1839 Potts versus Riverfront. The respective counsels have gone out to try to drill down on the objections held with regard to, or I should say, requests with regard to some discovery items. Somebody go ahead and update me on what the issues are, so that maybe we can drill down on those right now.
Judge, we've resolved one out of the 5 issues. I can place the one on the record, and then you can decide the next 4. Is that okay?
That sounds good. 20%.
Okay. Number 5 in our interrogatories asks, please provide the names of all Riverfront Tower apartments. Judge, can you hear me okay? I was having audio issues the other day.
It's a bit cloudy, but I am listening carefully. Let me ask my court reporter. Are you hearing Mr. Hill okay, Madam Reporter?
Yes, Judge, I can hear him.
Okay, go ahead, Mr.
Okay. Hang on one second. Number 5, please provide the names of all Riverfront Tower Apartment staff members or independent contractors that were employed to work at Riverfront Towers Apartment from July 2018 to November 2020. We've agreed to limit that to maintenance staff only. Is that right, Mr. Miller?
Yes, that's fine.
He may or may not answer number 6, which I'm okay with. The real issues, Judge, are 7, 8, and 9. And as a preamble, if I may, Judge, before you address my concerns, the deposition that we took yesterday was of Mr. Lavelle. He was the active manager over Mr. Potts' apartment complex during the time Mr. Potts vacated. He testified, and it's undisputed, that sometime in June or July of 2020, Mr. Potts brought it to the apartment complex's attention. There was a roach infestation. Mr. Lavelle also testified that sometime in November, Mr. Potts left. It's uncontested that Mr. Potts sent a notice on October 28th, 2020, that he was vacating, and he did vacate, I think, on November 3rd or 4th of 2020. Mr. Lavelle testified that he didn't find it out of the ordinary to have a roach problem for 3 to 4 months. He also testified that in his professional opinion, in the real estate management business for 10 years, that it wasn't uncommon for a complex to spray weekly for 3 to 4 months, and that as long as the landlord was spraying, he didn't feel that the actual tenant had a right to vacate. And that's the crux of it, Judge, is that Mr. Potts dealt with a roach infestation for 3 to 4 months. During the deposition, we went over pest control invoices that showed not only did Mr. Potts's unit 15G experience pest roach problems, it became apparent that the units above and below, below, Judge, units below also at some point had roach infestation issues within the apartment complex. So my request for 7, 8, and 9, 7 says, please provide names of any and all residents of Riverfront Tower Apartments that made claims about rodents or roach infestation in their unit, whether apartment or condominium, between July 2018 and November 2020. Mr. Miller objected, this is overbroad, request is irrelevant, and they won't disclose any names. I suggested a protective order. He rejected that. So if the court wants to address that, Mr. Miller, I'm assuming is going to have a response, but I think it's directly relevant because that's the sole basis for Mr. Potts terminating the lease early, is because he had to endure 3 to 4 months of roaches. Go ahead, Mr. Miller.
Judge, this is why I have a problem with.
Let me understand the frame of your request in the first instance. You said you're requesting from July of 2018 through August of 2020?
November 2020, that's when Mr. Potts started his lease.
All right. Go ahead, Mr. Miller.
Yeah, so Judge, this is why I have a problem with the way that the things are presented, because Mr. Hill told you half the story, which is what Mr. Hill tends to do. He didn't disclose to you that we provided to him a log of all of the apartment numbers that had been provided this type of service. We just didn't provide the names. We gave him a log of the apartment numbers. He doesn't need the names. That's because otherwise it's a fishing expedition. And number 2, we don't operate the condominium tower, Judge. So we don't have records related to the condominium tower. And third, it's completely and totally irrelevant what other residents may or may not have. This case is about Mr. Potts. Mr. Potts moved out before the end of his lease. The question before the court is whether he had a valid basis for doing so. That's it. It doesn't matter what anybody else did, thought, had, experienced. It's completely irrelevant.
May I respond, Judge?
Just a moment. I don't know that it would be completely irrelevant as to whether or not there was a persistent condition that was at work on the premises that there is evidence that persons in close proximity to where he was residing was also having the same problem.
Right, but we gave him the list of the apartment numbers and the pest control logs from the pest control service provider. What does he need the names of the people for? Is he going to try to solicit them to file an action on their behalf? I mean,
No.
what is the purpose of their name?
Judge, can I address that?
Go ahead, Mr. Hill.
I think this is the only time I've actually agreed with Mr. Miller on anything. And the one thing I do agree is the condo should be excluded, because I learned yesterday that they don't manage the condo. So I'm okay excluding that. What Mr. Miller is telling you is not the truth. He supplied one log from 1 month, one log, 1 month, that there was treatment done for roaches on 40 apartments. Just so happens, Judge, it happens to be the month after Mr. Potts leaves. They treat all of these apartments. It is ridiculous that he is trying to not give us that information so I can contact them? Because I will guarantee, I'm not soliciting other plaintiffs. I'm defending my business partner. The judge, Court, you know this, that Mr. Potts is my partner. I'm defending him. I think I should have the opportunity to talk to each one of the tenants that had issues with roaches to see how River Tower Apartments handled their situation. Did they give them a notice? Did they get countersued? No, right? That's what I want to find out. It's completely irrelevant. The condo, I agree with Mr. Miller. But as it relates to a one-page document saying we sprayed a month after Mr. Potts left, that's not sufficient. I'm not going against Facebook, right? I'm not done, Mr. Miller. I'm not done. Okay, I'm done.
Your Honor, this is why when people file motions to compel discovery, they should actually file a written motion. I was completely blindsided today. I went back and I looked at my emails from May of 2022. Mr. Potts never sent me an email claiming that anything was missing. And now Mr. Hill just stands up here in open court and tells you we provided him one document. But he questioned Mr. Lovell yesterday on about a half a dozen documents that we had provided and more relative to the pest control services that were provided. We provided a log. I object to this proceeding where Mr. Hill can just stand up and make things up without any evidence. He hasn't shown you one thing. He's just telling you, and he doesn't even read the answer in completion. He stopped reading the answer and left out the part that we provided them the logs of the apartment numbers. He just left that off. And I think the court should end this, because this discovery was answered on May 24th. And here it is on July 26th. Discovery is over. They did nothing. And they come to court and they say, well, we want to file a motion to compel discovery and we're just going to wing it. I have a real problem with that, Judge.
Mr. Potts told you, Mr. Miller, you know that.
There's no email, sir. You're wrong.
Yeah, listen, you guys spoke on the phone trying to resolve this thing.
John,
Sorry, Judge.
Here's the interest that I have is to get at, on this last day of discovery, to get at relevant information that may be in the hands of one party that may be relevant to the proceeding. That's the test here. That's what the test is all about. And so it would seem to me that the period, because Mr. Hill, it seems like you're asking to go back to 2018.
Judge, that was a baseline from Mr. Potts took over the lease. If the court wants to restrict that, I'm okay. If you want to do 2020, I'm okay with that.
Yeah, what I'm actually thinking is that it looks like to me that the period that would be most relevant in regard to this matter is the period of June through December of June through December of 2020.
Agreed.
As to what laws there are regarding any treatments that may have inured to the various properties in this particular building during that period of time.
I agree, Judge.
Provided that.
I'm sorry, Mr. Miller.
We provided that, Your Honor. He wants the names of the residents. That's what we didn't provide.
Well, we're going to deal with that secondarily. First of all, I want to make clear that my order addresses the period June through December of 2020. It allows for the presentation of logs and information relative to addressing any complaints regarding roaches or rodents on the premises during that period of time, and providing information in that regard. Also, any agreements that may have been reached with tenants during that period of time for them to vacate the premises as a result of complaints regarding conditions on the premises would be, I'm requiring that such information be disclosed. I'm not requiring the disclosure of individual names, but I am requiring the disclosure of persons who, that is, what units vacated the property, if there were any agreements and or lawsuits secondary to those persons vacating under claim that there was a rodent or roach problem on the premises.
Judge, that kind of roll, and I'm writing this down, I'll prepare an order. It kind of rolls into number 8, where we make a request for we're making for the names of the residents. I know you're not going to allow that, but we want to know how many tenants terminated their lease before the natural expiration because of a rodent or a roach infestation. Would the court allow us to do that as well?
That's not what Your Honor, that's not what the request requested.
I know, but he's going to say no to the names, Mr. Miller. So I'm trying to be proactive here. I'm trying to be efficient.
What you just stated, Mr. Hill, is what I'm allowing under this order. Notwithstanding what any one particular interrogatory may have said, or what 3 of them collectively may say, that is the I'm setting the parameters on what is required to comply with the discovery, whether artfully presented or not. With the discovery demand, I'm setting the framework and the parameters for what I'm allowing. And so I will not require that names be produced. I will require that processes be made clear on the specific issue of what was done by way of spraying or whatever with regard to the property during the window that I've already indicated. What were the complaints, who vacated, and whether or not there were lawsuits or deals reached as a result of any vacating of properties under complaint of rodent conditions or roach conditions on the property.
Judge, may I just summarize so that way this when I submit the order, Mr. Miller and I can be on the same page. From June 2020 to December 2000. Sorry, you didn't say yes. May I do that, Judge?
Yes, go ahead, Judge.
Okay. June 2020 to December 2020, logs and or complaints regarding roach or rodent infestation. No names, but any agreements between the tenants and the landlord, any lawsuits that were filed between June to December regarding roach or rodent infestation. How many tenants terminated between June and December because of roach or rodent infestation? That's it.
All right,
pretty much, right?
I think that would be included in that would be the logs of why the term doesn't want to come to me, where they sprayed place where they
I think we have that. It's just the complaints from the tenants that we don't have. So I'll put in there any additional logs or complaints from tenants, but I think we've encompassed everything that the court addressed.
All right, very well. That's of course what the court is ordering at this time.
How much time do you need, Mr. Miller?
21 days.
Remind me, Judge.
21 days.
I'll submit an order, Mr. Miller, today, Judge, and hopefully we'll have it over to you via email today.
So ordered. All right, thank you.
Thank you,
Wait,
Judge.
we were here for a pre-trial.
Yeah, and let's get a final date to get this all resolved. How much money is involved in this?
4,000, right?
Sorry?
4,000.
All right, John. All right, so you're likely to file a motion. So let me give you let's put it out for about 45 days, and the parties have a chance to deal with any motions that you want to file.
Thank you.
Set the motion hearing day for
September 14th.
September 14, 2022. That's going to be at 10 o'clock a.m. September 14, 2022, 10 o'clock a.m.
Is that also the pre-trial if there isn't a motion filed?
Yeah, it's a pretrial motion date.
Okay,
Pretrial day. Yes, sir.
very good.
Thank you, sir. Good day to both of you.
Have
Thank
a
you,
nice
Judge.
day, Judge.
All right, this is case number 21-165-707. This is Jacqueline Spearman versus Across the Park Apartments. The matter is before the court. So I set on for trial on today's date. Do I have Jacqueline Spearman on this Zoom, please?
Yes, good morning, Your Honor.
All right, good morning, Ms. Spearman. For the for defendant Across the Park, your appearance at this time, please.
Good morning, yes, good morning, Your Honor. Brian Butch, RP 66250. I appear on behalf of the defendant.
All right, thank you, Mr. Butcher. Good morning to you as well, sir. So it looks like this is a complaint that was filed secondary to the defendant moving out of the premises controlled by Across the Park Apartments. And it sets forth a number of allegations and suing for slander, harassment, falsely accusing plaintiff, falsely evicting plaintiff, and mental anguish. Several of these items would not really state a cause of action in the state of Michigan, but I'll address that as we go forward in this matter. All right. Anything preliminarily at this time, Mr. Butcher? I'll come to you, sir.
Yes, Judge. So when we filed our responsive pleading, our answer, we also filed a counter complaint. No answer was filed to that counter complaint, and so at this point, we would request a judgment in favor of the counter plaintiff pursuant to MCR 2.108A1. The defendant would have, the counter defendant would have 21 days to answer. Also pursuant to MCR 2.110B1, and specifically MCR 2.110E1 indicates that any allegations not specifically denied are deemed admitted. And so, Your Honor, we would contend that my client is entitled to a judgment. Whether the court ultimately deems that that money would offset by whatever award of damages you might award the plaintiff, I guess we'll have to wait and see. But I would contend that we're entitled to a judgment at this point.
All right, and specifically, simple from the record, your damage plea in your counter complaint, sir.
Certainly, Your Honor. This, as the court noted, our counter complaint stems from the former tenancy of Ms. Spearman at my client's property Across the Park Apartments. When this counter complaint was filed, Ms. Spearman was actually still residing in the unit. And so the damages had not been fully calculated at that time. However, I had noted in the counter complaint that Ms. Spearman's rent was at the time $284 per month. That Across the Park was, of course, precluded from accepting rent during the pendency of a termination of tenancy case, which was pending at the time before Judge Garrett. That case having case number 21351-063-LT, and indicating in the document that the rent would, of course, continue to accrue so long as Ms. Spearman continued to reside in the premises. Ms. Spearman did ultimately vacate the premises in, I believe, late November of 2021. She did have a security deposit in the amount of $323, which was applied to her then balance of $1,176.79. And then the property subsequently received another payment from a housing assistance payment, bringing her current balance, her final total balance, down to $206.79. And I do have a ledger that I can share on my screen to support that averment.
All right, so Ms. Spearman, you never filed any written response to the counterclaim in this matter. Why didn't you respond to the counterclaim, ma'am?
I did not know how to do that, Judge. I am not a lawyer. I'm just here trying to represent myself and have the truth be told. So that is just something that I just did not know how to do.
All right. Well, you know, the interesting thing, of course, is that the law requires that when you practice before the court, that you're held to the same standard. I know sometimes that perhaps doesn't even seem fair, but it holds you to the same standard as a lawyer. You'd have to search out the rules so that you understand how to proceed before the court. But because you didn't respond, by law, the plaintiff is entitled to a default on that matter. So I will grant their petition for default, but I guess the fortunate part of this is that the balance that they are claiming herein is $206.07. But any funds that they've withheld by way of a security deposit has been applied towards the damage claim that they brought before the court. When you didn't respond to that, they win by default, and that's the order that I'm going to sign in that regard. We still have your matter that is before the court at this time, and I will hear the complaint that you've raised before the court and make any decisions as to whether or not the claims are viable, and if so, what the damage amounts might be in relationship to those claims. So that's my determination at this point. Are you able to come on screen visually? Are you able to allow me to swear you in as a witness at this time, ma'am?
Sure.
In other words, can you turn your camera on so I can see you?
Yes, Your Honor.
If you do so, so that I can swear you as a witness. Sorry. There you are. All right. And so your name, for the record, is in fact Jacqueline Spearman. Is that correct, ma'am?
Yes, that's correct.
All right. You resided at the property, the Annabelle property in the city of Detroit at one time. Is that true?
Yes.
And let's see, one more thing for us. All right. So do you solemnly swear or affirm that the testimony that you're about to give, ma'am, is the truth, nothing but the truth, so help you God?
Yes, I do.
All right. All right. Thank you, Ms. Spearman. Counsel, you waive opening statement at this time, sir?
Yes, Judge.
You wish to reserve opening statement at this time, is that correct, sir?
I would, yes. Yes, please, Your Honor.
All right, thank you. Thank you. All right, Ms. Spearman, I'm going to allow you to tell me under oath what this matter is all about. And let me begin by just asking you a couple of questions. How long did you live at the Across the Park apartments, ma'am?
My lease began in July, towards the end of July of 2020. And I was forced or asked by eviction to move in July of 2021 based on false allegations.
Okay, we'll get to that in a moment. When did you actually move out, or well, when were you last at the apartment, if you will?
November 24th, if I'm not mistaken, Your Honor, of 2021.
Got it, ma'am. And when you entered into the apartment, you signed a lease, or did you sign a month-to-month agreement? What did you sign, ma'am?
It was a lease agreement. However, I was advised in January of 2021 that it was actually a month-to-month because it was subsidized housing.
Okay. All right. So, and in this subsidized housing situation, this was an apartment that you lived in, or a single house, or what was it, ma'am?
It was an apartment, Your Honor.
Okay. And describe it for me, if you will. Was it a 1 bedroom, 2 bedroom, 3 bedroom? What type of apartment was it now?
It was a 1 bedroom apartment. It,
Did you live alone?
yes, I did.
All right. And so at some point, you had some problems or issues with the with your occupancy there. Is that correct, ma'am?
That is correct.
All right. When did you first start having problems? I know that you moved in July 2020. When did you first start having any problems regarding the property?
I actually began having problems August the 3rd of 2020. So it wasn't even a month. I received a notification on my door that I had not paid my rent for August and that I had to vacate the premises within 7 days. So I took that notice to the manager of Across the Park apartment, where she tried to insist that I double pay rent. And that's when all my problems began. I showed her my receipt, and she was kind of snippy and mean about it. And that's when all the harassment and being stalked and vandalism to my vehicles began after that.
All right. So let me ask you then, when you entered into the property, you paid some money to come into the property. Is that correct, ma'am?
That is correct. I paid the security deposit that was asked of me. I also paid partial rent for that month because I moved in so late in the month of July. So it was kind of like a prorated rent. I also came to find out when I presented that my rent receipt to the apartment manager that they had overcharged me for my security deposit.
All right. How much was your security deposit, ma'am?
It was $323. That's what I was quoted over the phone by her prior to moving in.
Let me stop you. Let me stop you. At the time that you moved in, is that what you paid, ma'am? $323?
That is yes, Your Honor.
Okay. And you also paid prorated rent. You recall how much your prorated rent was?
I believe it was like $150 something.
Okay. All right. And so then you get to August and they're demanding the rent for the month of August at that time. Is that correct?
That's correct, which it had already been paid.
So you told me you made a security deposit and you paid a partial month for July. Did you make another payment at some point for August?
Yes, I made a payment in August around the 1st, the 2nd of August.
Okay.
I had never been late with my rent, Your Honor.
All right. And so they gave you a notice, but you indicate that notice was not correct because you had already paid, correct?
Yes, Your Honor.
All right. All right. Now, in the time that you stayed there, you indicated to me that things started happening from that point. You said that that you were stalked and harassed. Tell me what you're talking about regarding beginning in August. Now, go ahead. I'm listening to you.
Thank you. I don't know if this person is a friend or if this person was an associate of Miss Jones. I just know that they were holding conversations with each other. This young lady was stalking me. She kept waiting for me to get out of my car at the parking lot, and then she would follow me into the building. And I had to ask her after she did that on the 4th time to please don't do that anymore. I actually went to Miss Jones, which is the apartment manager of Across the Park, or was, and I asked for that individual's name. I didn't know who that person was. I wanted to make a formal complaint against that individual. She told me she refused to give me that individual's name and told me just don't say anything to her because she's crazy. That's what she told me. And I told her, well, I need to make a formal complaint against her because she's becoming a threat to me. This is the fourth time that she has been following me into the building and waiting for me to get out of my car.
Now, Julia, did you ever receive any information that that person worked for Prosper Park?
I did not, Your Honor. I did not get any information regarding that person, although I did submit a fax to First Management, which was the company that was managing across the park. I submitted a fax to them indicating that this was occurring. And they provided no help or anything either in that particular situation.
All right. To the best of your knowledge, was that person a resident at the property?
That I am unsure of. That again is why I was trying to get information from Ms. Jones so that I could file a proper complaint. There was another incident twice where a person was a resident at the building, tried to trick me with a vacuum cord twice. He literally was vacuuming the carpet in the hallway, and when I got off the elevator, he kept lifting up the cord. And so I was able to make a formal complaint against that individual because it was apparent that he was doing work for them. That also happened, if I'm not mistaken, around the end of August, the 1st of September of 2020.
All right. Do you know that person's name?
I do not. It was not provided to me. But they, the manager, Ms. Jones, knew exactly who that person was, and they informed me that they would deal with it.
Did you ever find out what the lady's name was, the one that would come to your car and follow you in the building? You ever find out what her name was?
I did not. I asked again, Ms. Jones for her name. She refused to provide it. Again, her statement was, just don't say anything to her because she's crazy.
With regard to these two individuals or situations, did you ever file any police reports or anything along those lines in regard to these two persons?
Not to those two individuals, but I began filing police reports. I think I have about 9 or 10 of them because I don't know if you want to call it harassment or, well, what I felt was harassment did not stop. It continued. Then I believe that person that was stalking me because she literally came to my car with something in her hand, but she didn't know I was in my car. Vandalism began happening to my vehicles, including 2 rental vehicles.
And what vandalism occurred regarding your vehicle, if you will?
There were dents, there were large, huge scratches all over the vehicles, on the windows, dents on the hood of one vehicle. Another vehicle had to be totaled out by the insurance company. If I'm not mistaken, they told me that it was over $7,000 worth of vandalism to the vehicle. So they just totaled it out altogether. That occurred in June of 2021. The vehicle was just purchased in May. If I'm not mistaken, around May 18th of 2021. So over $7,000 worth of damage in less than a month. And again, that woman was the person that attempted to vandalize the vehicle while I was in it. She just didn't know I was in there.
And did you, I take it you filed police reports regarding those incidents, is that correct, ma'am?
That's correct, Your Honor. I provided those police reports to Mr. Bouchard.
Yes. All right. So tell me what else, if anything else happened along the way. You were telling me about harassment and things along those lines. Tell me what else you wish to bring to my attention at this time.
Yes, Your Honor. There was an incident on June 11th of 2021 where the security guard was in civilian clothes and waited for me to pull up to the front of the building. There's a wrought iron gate in front of the building.
Yes.
So she was standing at the wrought iron gate with her weapon shown. She did not have on her security shirt like they normally wear. She just had on a regular black t-shirt, but her weapon, which was a gun, was just showing. And I got out the vehicle, walked around the wrought iron gate to go inside of the building through the door. She actually was at the door blocking me from getting into the building. I had to say excuse me to her to enter into the building. As I entered the building, she entered right behind me. I took that as intimidation because that's what they were doing, intimidation and bullying tactics in my view. I immediately went upstairs to my apartment and called the police. The police did not come out. The person on the phone with 911 advised me to go to the 4th precinct, which was the closest precinct to my location. I did so. I also included that report with my other police reports to Mr. Bouchard. So the incident that that was actually presented to the eviction court, Your Honorable Garrett, saying that I pulled out a gun on June 25th on a security guard, that is untrue. I did not do that. That security guard brandished her weapon at me to intimidate me.
So let me ask you, did you ever get did the security guard pull a weapon out or anything towards you or anything?
No, Your Honor, she did not.
All right. And when she followed you into the building as you described, did she follow you up to your apartment or she walked behind you coming into the building? What happened in that
She
regard?
walked behind me coming into the building, and then she went into her station. They have a station where they sat that was like plexiglass up. So she did not follow me to my apartment. She went into her station. I took that as a threat, immediately went to my apartment and called 911.
All right, you told me about that. Did the security guard say anything to you when she approached you or as you were approaching the entryway?
She did not. When I said excuse me, she did move out the way and allowed me to go into the apartment building door. Again, she followed me in there, but yes. So no, Your Honor, she did not.
All right, ma'am. And but you felt threatened under that situation. You felt that you were being intimidated. Is that correct?
That is correct, Your Honor, because of everything that had been occurring since August of 2020.
All right. And you may continue to tell me about other things that you want to bring to my attention at this time, if you wish, ma'am. Go right ahead.
Sure. I also signed a lease agreement in July of 2021. And I asked the apartment manager for a copy of that lease agreement. They refused to give it to me. Their excuse was they could not find it. So that is why I applied in my lawsuit that they used non-factual paperwork to evict me, because they used the lease agreement that I signed in April, but I actually signed a lease agreement somewhere in July the 20th. I'm not sure of the exact date, but it was somewhere in that time frame, because that I moved into the building in late July of 2020. But I did sign another agreement in July of 2021.
So you were planning to stay at the building because a year later you signed another agreement to extend your lease. Is that correct?
Yes, I was, but I did not plan to stay. I actually submitted in June. I want to say June the 5th, if I'm not mistaken, a 30-day notice to leave. I had found a place, but that ended up falling through. And so I contacted First Management, a Miss Tasha there, who was a manager over the manager of across the park. I explained to her about the place that I had was going to move into. That agreement fell through, and if I could take back, take back my 30-day notice. She agreed to that, and she allowed me to write out that I was rescinding my 30-day notice, and presented to Ms. Jones, the manager of Across the Park. I presented that, if I'm not mistaken, on June 19th.
All right. And then on June.
So they allowed me to rescind that 30-day notice, Your Honor.
Gotcha, ma'am. Okay, so after you signed to stay in the apartment in July, and then ultimately you moved out in November, or were you evicted from this property, or did you move out yourself? What happened?
No, I was presented with an eviction notice because I had been accused of pulling a gun out on the security guard and shooting at her, which I did not do.
Okay.
That was the whole basis of the eviction, and that was in July of 2021.
Okay. And so, someone alleged that you pulled a weapon and fired it at someone in July of 2021. Is that correct?
That is correct. The lawyer, the attorney for the defendant, that in this case, they were the plaintiff in the eviction case.
Gotcha.
Their attorney actually said that. That is not a part of the eviction, but that's what he told the judge, and she believed him.
All right. And so the judge in that case granted an order to have you move from the property. Is that what happened?
That is correct, Your Honor.
So did you move out, or at some point did the bailiff come and move you out? What happened?
I moved out. The other attorney, it was not Attorney Bouchard at that time. I'm not sure what that attorney's name was. They kind of was in and out. It was one day it was Attorney Bouchard, then another day it was this other attorney. But he and I came up with an arrangement, and they granted me time to move out.
All right, gotcha. All right, so it sounds like to me, you tell me if this is true or not, that your complaint has to do, the main part of your complaint seems to have to do with being falsely accused, and then this eviction process starting as a result of that. Is that kind of the heartbeat of this, other than the other things that you told me?
That is correct, Your Honor.
All right, anything else you want to bring to my attention, ma'am, at this time?
Yes, this, as a result of this eviction case, and this case as well, I've been under a lot of stress, pressure, having panic, anxiety attacks, depressed. It's been very, very difficult to deal with this. I've had to move into a place that is much more rent. I was in subsidized housing at that time. So it's just I'm just under a lot of distress, and like I said, having panic and anxiety attacks and things of that nature based on this whole experience with Across the Park and what they were doing.
now in November, before the eviction, before they removed your stuff, in November, you moved out yourself. Is that what happened?
Yes, Your Honor, they did not have to remove my things. I had to pay for a moving company to move my things. I had to move abruptly because the I'm sorry, Your Honorable Garrett, she did not ask for any evidence or anything. She just believed what the plaintiff had said, and that was that. So I had no other choice except to move. I could not even defend myself in her court. She kept cutting me off.
All right, ma'am. All right, thank you very much, Ms. Spearman. Mr. Bouchard may have some questions for you at this time, and you may proceed at this time, sir.
Thank you, Your Honor. Ms. Spearman, going back to the eviction case, you were represented in that case by an attorney of your own, isn't that correct?
That is not correct. I did not have an attorney. That was legal aid that provided counsel. They explained to me specifically that they were not my attorney.
Okay.
They said they were not what, ma'am?
They specifically advised me that they were not my attorney. A bailiff actually pulled someone over to assist me from legal aid. They told me that they could not be my actual attorney, but they asked me what happened, and they said that they could give me advice. That was all that they could do, and that's what they did.
All right. Did they appear in court with you when you had the hearing?
Yes, they were there.
Okay. Go ahead, Mr. Bouchard.
Your Honor, would the court give me permission to share my screen and show a document?
You may at this time.
It appears that function is disabled, Judge.
Let me try to enable it. After all this time, yeah.
I get it.
You should be able to do it now.
Thank you, Judge. Okay, Ms. Spearman, are you able to see the document that I've just shared on the screen?
Partially, I'm increasing it so that, or blowing it up actually, I'm sorry, so that I can see it. It's partially, I can only see up to line
I'm gonna make it,
4.
sure, yep, I'm gonna make it a little larger on my end as well, so that might make it easier to see. Can you see that okay?
I can see up to line 3, actually. It stops
Right,
at 3, further conditions.
Correct, I will scroll.
I think it's gonna move it up some. We just wanted to make sure that you're seeing the document through that point 3, and if he moves it, if he refers to anything else, then he would have to move the document and show us the rest, okay?
Thank you. Thank you.
You may continue, Mr. Bouchard.
Thank you, Judge. Okay, Ms. Spearman, so this is a document entitled at the top in the center, consent order for conditional dismissal. Is that correct? You see that up at the top?
I do.
Okay. And do you see listed here in this box, you may see my cursor moving around it. I will see if I can highlight the area. There's an attorney identified, Mr. Tom Barashai, as defendant's attorney. Okay. And I'm going to scroll down to the bottom of that document. And that document was signed by somebody indicating that they were defendant's attorney. I can't read the signature myself, but it appears to have a T and a B in there somewhere. Do you recall whether or not Mr. Barashai signed this document on your behalf?
I am not aware.
Okay. But Mr. Barashai was acting as your attorney at some point during the course of that case, was he not?
he acted as an advisor to me. Again, he did not, again, they told me, because he, initially a woman was there with me the first time I went to court. The deputy actually pulled someone. They told me they were going to pull someone because I had no legal representation. I was just there to represent myself at that point during the first eviction hearing. And so the bailiff, I'm sorry, went and pulled someone from where I'm sure it was a young lady at that time from legal aid. And again, they let me know that they are not my attorneys, that they were there to provide legal advice. So that it was my understanding of them being there with me.
Okay.
Very well.
You never actually went to trial.
Let me stop you for just a moment. Let me just indicate for the record that the document is presented, the court has to take judicial notice of the order presented with Judge Garrett. And the court would have to find from that document that counsel was present and counsel represented Ms. Spearman. Now, Ms. Spearman, I understand that her testimony is that they were advising her that she represented herself, and then an attorney was presented. But I'd have to take judicial notice that she was represented by counsel in a formal sense, because there was an attorney that was present and that signed off on the documents. I also hear her testimony regarding this matter about what she thought about the arrangement, but from a legal standpoint, she was represented by counsel because an attorney signed off, attorney was present, and attorney gave her advice. Just giving a client advice can engage the services of an attorney, and certainly signing off on a document on the defendant's behalf is in fact representing that defendant. Now, I don't expect Ms. Spearman would understand all of the implications of that necessarily. I just know legally that that's what that means, is that there was an attorney involved. So I would have to make that finding. And counsel, you may continue otherwise.
Thank you, Your Honor. Does the court wish me to formally seek to submit this into evidence, or it sounds like the court's taking judicial notice that this document is what it purports to be?
I'm sorry, sir, I didn't hear you there.
My question was if the court requires me to seek to submit this document into evidence, or if the court's finding and taking a judicial notice is sufficient at this point.
The court has to take judicial notice of that document because it is an order issued by this court.
Okay, thank you, Your Honor. Ms. Spearman, you indicated that there were a number of instances of vandalism, dents and scratches, totaling one vehicle completely. Do you know if any arrests were made regarding those charges of vandalism?
There were no arrests made. However, I was in communication with a Detective Gibson from the 4th Precinct. She advised me that, well, I literally saw her come to the building, so I know that she was there, but she advised me that the apartment manager, Ms. Jones, refused to provide any camera footage. I have a handicap placard, so I always park in a handicap, which was right in front of the camera view. According to Detective Gibson, Ms. Jones refused to provide any camera footage of the incidents that I recorded, and they couldn't make her.
Do you know if Ms. Gibson ever issued or had issued a warrant to obtain that information from Ms. Jones and across the fire department?
I know for a fact that she did not, because I asked her if she could subpoena that information or anything of that nature, and she indicated to me that this was not like a murder case or I guess a severe case where they would do that, and that
so no arrests were made. Were any tickets issued to your knowledge to anyone regarding that damage?
Not to my knowledge, no.
Okay, so the bottom line is you don't really have any idea who who caused the damage to your vehicles, correct?
I have an idea of one person that caused the damage to my vehicle because they were on their way to do it as I was sitting in the vehicle. And that is that individual that I spoke of that was stalking me, that was having communication with Ms. Jones on several occasions. I tried to get that individual's name. I'm sorry.
Right. Do you, okay. And you previously testified that you're not aware that that person works for Across the Park or works for Ms. Jones or with Ms. Jones, correct?
That is correct. I have no idea.
Okay. You testified about a June 11th, 2021 incident with a security guard. And I just want to reiterate, you testified that the guard didn't say anything to you when you said, "Excuse me," correct?
That's correct.
And the guard did in fact move when you asked, correct?
That is correct, yes.
Okay. And the guard, when following you into the building, went to the security station as opposed to following you any further beyond that point, correct?
Correct.
Okay. Your Honor, as to matters that have been testified to, I don't have any further questions at this time.
All right. Thank you, Ms. Spearman. Anything else you wanted to bring to my attention at this time?
I think that is it, Your Honor. I don't want to bring in hearsay into this hearing because it would just be hearsay. So I'm trying to obey the court laws as best as I can. So I think I have provided you with all of the information that created this this lawsuit that I filed.
All right, now. All right, thank you very much, Mr. Spearman. All right, any other witnesses or anything that you wish to present to me, ma'am?
Again, that would be hearsay. So that's why I did not present any witnesses.
All right. All right, then the plaintiff then would rest their case at this time, having presented the evidence that she wished to present, and having made allegations within her complaint alleging damages as a result of the conduct that she's testified to. All right, counsel.
Thank you, Your Honor. At this time, preliminarily, Your Honor, I would move for a directed verdict pursuant to MCR 2.516. The plaintiff in this case has not presented any evidence to establish that the defendant is liable for any damages. You know, there's no indication from the record that the defendant caused any damages or even participated in any of the alleged, I guess, nefarious acts or harassing acts. It all appears to be speculation as to people who may or may not be associated with management who did these things. Ms. Spearman is conflating management's either inability to disclose the names of other people or to disclose video evidence to the police for a whole host of potential liability reasons with some sort of affirmative disregard for Ms. Spearman's well-being. And so I don't believe that Ms. Spearman has properly determined that damages were caused by my client. And in fact, Ms. Spearman has not really alleged any damages at all. There's no proofs in the record at this point. Ms. Spearman has testified that there was some damage to her vehicle done by this mystery person who has no established connection with Across the Park other than perhaps conversing with Ms. Jones from time to time. There's simply no evidence on the record that damages occurred. Certainly no documentary evidence. No estimates for vehicle repairs. Ms. Spearman did indicate some having some experiences of being unwell. There's no evidence on the record of any hospital bills, treatment bills. There's simply no evidence of damages, and much less that those damages would have been caused by any action or inaction of across the park. And for that reason, Your Honor, again, as a preliminary matter, before I would begin any case in chief, I would make the motion pursuant to MCR 2.516 for directed verdict.
All right, Ms. Spearman, the nature of the motion that has been brought by counsel is to say that even if the court accepts your statements as made to the court, your testimony is made to the court, that they show some areas of displeasure and some things that may have caused you some distress, but that under Michigan law, he argues that they do not show a cause of action that is that the court can award damages on. He doesn't at this point dispute many of the things that you say as being true. What he's saying is that, Judge, even if you accept the things at this point as true on their face, they do not rise to the level of establishing the case before the court. Even if I accept if I view things in a light most favorable to the plaintiff, says he's arguing that even if you look at it from Ms. Spearman's perspective, she shows that there is some frustration. She shows that there were some disputes, that some persons may have followed her into the building, and some persons may have damaged her property. But she cannot show that that this was done as intentional or negligent acts by the apartment complex, but that they were things that occurred along the way that could be frustrating, but they did not give rise to a cause of action upon which damages can be awarded. So before I make a decision on that, ma'am, anything you wish to say at this time? Go right ahead, Ms. Spearman.
There is, Your Honor. Thank you. I think the eviction process and the presentation of an eviction notice to me is evident. That was presented falsely. I never pulled a gun out on anyone and shot at anyone, let alone the security guard. So that is evident. So I'm not sure why the council would think that that isn't evidence. That is evident. This whole case that we're in right now is a result of that. And that has caused financial and mental anguish to me, whether he knows it or not. No, I did not present my medical records to the court or to him, but yes, it has caused a lot of pain for me. Having to just uproot and move just out the clear blue sky, not knowing where you're going to go or anything of that nature. That would be enough to make a regular person have distress and things in their lives. I am handicapped, so that is even worse on me. That eviction is evident.
Right.
Where the plaintiff, which is his defendant now, proved not 1 inch of evidence that I literally pulled a gun out on the security guard and shot at her. That was the whole reason why I was evicted in the first place.
All right, ma'am. Thank you. Now, Mr. Bucciardo, your motion. Your response.
Judge, I just want to indicate that, notwithstanding Ms. Spearman's characterization of her experience with legal aid, she was represented in that landlord-tenant case, and she did have the opportunity to fight that case on its merits. She had a right to have a trial. And instead of exercising that right, she chose to settle that case. And as far as I'm concerned, that issue in that case are closed. I know that that's what prompted the filing of this case. In fact, it appears that I think our case was filed on August the 24th, and this matter was filed September the 9th. So it appears to have been filed in direct response to our filing of that case. But again, Ms. Spearman did have the right and the opportunity to fight that case on its merits, to have a decision made on that case on its merits, and chose to settle instead. So again, I don't think that any proofs have been given by Ms. Spearman, who is the plaintiff in this case, sufficient to allow the court to make an award of any kind. Again, she's not established any damages, period, much less that those damages were caused by the defendant in this case.
All right, and of course, you get the last word regarding that motion. So I'm going to make my decision now regarding the motion for judgment notwithstanding, but judgment based upon the proofs in this matter. When the court considers a motion for a directed verdict, the court has to view the evidence in the light most favorable to the non-movement, that is in favor of Ms. Spearman, and determine whether a rational trier of fact could conclude that the essential elements of the claim were proven, meets the burden of proof at this particular stage of the proceedings. As it relates to, first of all, the claims brought by way of various persons at or on the premises that may have in ways positioned themselves such that Ms. Spearman felt threatened, or persons that she had disagreements with regarding whether or not rent was paid at a certain juncture or not. The reality of it is that in looking at those items, that there is clearly not enough stated here to raise a cause of action to show that the complex that she is suing through its agents were involved in causing damage to the plaintiff through various intentional and or negligent acts. Moreover, the issue regarding the motor vehicle and damage to the motor vehicle was taken through to the right channels, that is to law enforcement, in an effort to try and resolve what clearly appeared to have been someone causing damage to Ms. Spearman's vehicle. She indicates that at least on one occasion, there was something in the nature of $7,000 that was caused of damage that the insurer of that vehicle estimated or apparently took care of. There is nothing on this record that shows that the apartment complex was engaged in the practice of allowing someone or telling someone or negligently permitting someone to cause damages to her vehicle. And moreover, any damages that did in fact occur, those damages were remediated through the various channels that they would normally be remediated through some type of insurance claim. And Ms. Spearman did the right thing by contacting police to have the matter investigated. The final part of the equation that I had to think about and look at has to do with the claim regarding the filing of a complaint to end the tenancy in this matter. That matter was adjudicated by a judge of this court. In the process of that adjudication, the parties reached an agreement to part and go their separate ways. It appears that there was a complaint or a statement raised within the context of that complaint that Ms. Spearman had pulled and or fired a weapon at someone at the premises, and that statement was offered for the purpose of litigating a claim. It does not appear that such a statement, or there's no testimony that such a statement was made to any governmental agency, or that such a statement was made to in a criminal complaint such that that prosecution was brought against the defendant in that a false charge was raised against her within the context of a criminal proceeding. That would be quite significant in this case, should there have been charges filed, and then it proved that after charges were filed against Ms. Spearman, that those charges proved to be untrue, but that she faced criminal process as a result of those charges being filed. Well, that was not done in this case. In this case, there was apparently, based upon Ms. Spearman's testimony, an allegation raised in a judicial hearing that a weapon had been pulled and or fired by Ms. Spearman. And Ms. Spearman says that that is the predicate under which the landlord-tenant case was filed. That might have been, but the civil process allows for notice and opportunity to be heard, so that a judge may make a determination and reach conclusions regarding what happened or what did not happen. At some point, the case was resolved. So the parties came together and made a decision with attorneys involved to dispose of the case and resolve the case accordingly. Ms. Spearman decided to move without her case going to the full extent of litigation. She felt that she had been treated badly and she no longer wanted to reside there. She also testified that she felt that that the judge was not listening to her or was not going to listen to her. I hope that that was not the case, but I have to rely upon the judicial process and the fact that there was a lawyer that was involved with her, assisting her in some ways and helping her to reach a resolution that was agreed upon by both sides. That was the outcome of that, of the underlying cases, that it was agreed upon by both sides as to what happened in that case. And so the allegation that was made in a judicial setting offered for purposes of a judicial determination as to whether or not that was true. There was not a statement put out simply put out in public saying that something occurred as it relates to the Spearman. There was an allegation made in a judicial setting for a judicial determination to be made to test the veracity of that statement. That statement is not therefore a statement that is offered to defame or offered to soil her reputation. It is a statement put before a court for a court to test the validity of that statement in the normal course of the judicial process. With all of that being understood regarding this case, with the case having been resolved by the parties reaching an accord, a consent, saying that this is the way that these disputes should be resolved. I agree. They agree that we will resolve our dispute over this issue of whether or not there was a weapon or anything else. We'll resolve it by reaching an agreement for a conditional dismissal of the case, and the parties go their separate ways. That outcome, that agreement, that disposition in this case really determines the surviving prong in this case of whether or not there was a defamatory statement or a statement that was designed to cause harm to the reputation of the defendant in this matter, and whether that statement in fact caused harm to her reputation and whether that is actionable. I would have needed a determination of that issue on the merits before the court where that allegation was brought. And with there not being really a determination other than Ms. Spearman told me that the judge hearing the statement or testimony believed the testimony. That would work against her if the judge actually thought that the statement was significant enough and valid enough that the judge found the statement to be believable. And that doesn't mean that I believe that that occurred, but I was not the trier of fact on that particular issue. The judge that may have heard that, Ms. Spearman telling me that the judge, after hearing whatever evidence was presented, the judge believed the statement. With all of those things taken into consideration, as I must here, and weighing in the scale whether or not there is enough evidence, even if there is an allegation that proved that it is not true about Ms. Spearman having a weapon. When I weigh all of this in a scale, I have to determine, is that enough to carry the burden of proof in this case? When I weigh all of the evidence in favor of the proposition that Ms. Spearman has brought. And the fact of the matter is that it's just not enough here. There's not enough evidence for this case to go forward. And because there is not enough evidence, there is some evidence of some things, but it's not enough. When I put it in a scale, it just doesn't tilt the scale, even viewed in the light most favorable to the plaintiff, as I must do at this point. The case lacks sufficient proof to go forward. And for that reason, I will grant the motion for a directed verdict at the end of the plaintiff's proof. There's just not enough evidence for the case to go further than it has gone at this point. And therefore, the complaint in this matter will be dismissed for a failure of proof. And that is my determination in this case. I will sign the order consistent with the same. I do wish you well, Ms. Spearman. I've listened to your case carefully. And thank you, Mr. Butchart. I've listened to the parts questions that you presented. I've analyzed very carefully all the information that I have here. And it's just not enough information for this case to go forward. And so my order is as I've indicated. The case will be dismissed for the reasons indicated. I wish both sides well.
Your Honor, just as a matter of housekeeping, Your Honor, did you wish for me to present the orders? So there was a $206.79 default judgment issued on the counter complaints and a dismissal of the complaint in chief. Did you wish for me to present orders consistent with that to the court for entry under the 7-day rule?
Absolutely, sir. You can, in fact, you can present that by way of email without presenting it under the 7-day rule, because it is in fact the order and determination of this court. So you can submit it. I'll sign it. We'll make sure that that the defendant gets a copy of the order once it's been in.
Thank you, Judge. And just for ease of, I guess, the documents, I will probably present the judgment on a traditional civil judgment form and then submit a separate order regarding the case in chief. Is that okay with the court?
That's fine.
Okay. Thank you, Your Honor.
All right. All the best to both sides. Good day.